All right, I showed that we are here on defendant's motion. Is that correct?
That's correct, Your Honor.
All right, Mr. Cornwell, if you'd like to proceed.
Thank you, Judge, and may it please the court. The defendant are asking this court to rule that the plaintiff's claims in this matter, as alleged in their third amended complaint, are healthcare liability claims subject to the Texas Civil Practice and Remedies Code, Chapter 74. Just for a brief bit of background, this lawsuit, the allegations in this lawsuit concern Miss Pierce, who was a resident at Renaissance Austin, an assisted living facility in Austin, Texas, during Winter Storm Uri that occurred in February of 2021. And essentially, plaintiffs allege, among other things, that Harvest Renaissance failed to provide a safe environment for Miss Pierce, failed to appropriately monitor her condition, failed to properly equip the facility with emergency power, and failed to take reasonable measures to prevent her from developing hypothermia. And there are many other allegations, but I think that sort of sums up in a nutshell what plaintiffs are claiming. And as a result of this lawsuit, there were Chapter 74 reports that were filed by the plaintiffs. The defendants objected to those. The trial court overruled those objections, and then the defendants appealed those, which were ultimately dismissed by the Court of Appeals, and they ruled that the trial court ruled that the trial court was proper in overruling the objections. Since that time, the plaintiffs have filed a couple of amended complaints, and today we are here because in the plaintiff's third amended complaint, they make the allegation that their claims are not subject to Chapter 74 because the defendant was not duly licensed as an assisted living facility at the time of this incident. And that, what we obviously disagree with that. We have provided the court as Exhibit A to our motion, a copy of the license issued to Harvest Renaissance. And the license shows that it was issued under Chapter 247 of the Texas Health and Safety Code to operate a Type B assisted living facility from February 28th, 2020 to February 28th, 2023. So that encompasses the time frame of this lawsuit. Now, what plaintiffs are claiming is that the defendant was not duly licensed under the definition of Chapter 74 because there were deficiencies cited by Texas Health and Human Services during a post-incident survey. And because of those deficiencies, they're claiming that we aren't duly licensed and therefore not subject to Chapter 74. So in Chapter 74, the operative language here is that a healthcare provider is any person, partnership, professional association, corporation, facility, or institution duly licensed, certified, registered, or chartered by the state of Texas to provide healthcare, including, and then it gives a whole list, and one of those is a healthcare institution. And it defines a healthcare institution as one of the things is an assisted living facility licensed under Chapter 247 of the Health and Safety Code. And that's exactly what we have here. There is no evidence in this case at all that the license of Renaissance Austin was ever suspended, revoked, or voided during this time period. And the argument that plaintiffs rely on is unavailing for a couple of reasons. First is that it is clear and unequivocal that Renaissance was an entity licensed by the state of Texas under Chapter 247 of the Health and Safety Code, which is a designated healthcare institution under the statute. And plaintiffs relies on two cases to support their position. One is Complex Rehab Technologies v. Molina. The other is 4J's Community Living Center. Those two cases are not applicable here because in the Molina case, the defendant only had authority to act as a device distributor under a license issued under Chapter 431 of the Health and Safety Code, which is not enumerated in the Chapter 74 statute as a healthcare provider. And so it failed to present evidence demonstrating it was certified by the state of Texas to provide healthcare. In the 4J's Community Living Center case, the defendant failed to, had testimony that it complied with rules and regulations, but it did not produce a license, even in the face of evidence saying it wasn't licensed. And that's the exact opposite of what we have in this case, Your Honor. And so because of those, and because of the statutory definitions, it's the defendant's position that we are a healthcare provider under the statute entitled, and that Chapter 74 governs these claims. And I'll move on from the Duly license issue unless Your Honor has any questions about that issue.
No, I don't. I understand. I've looked at both your motions briefly. I understand what the names are going to say. Go ahead. Yeah.
Thank you. And so now we'll move to whether or not plaintiff's claims are healthcare liability claims. There are the plaintiffs cite the Ross decision from the Texas Supreme Court, along with numerous other decisions that they claim show that their claims are not healthcare liability claims. And I would just like to note that those cases are not likened to this case at all. Ross, Gallivan, Reddick, Ramirez, each one of those cases that the plaintiffs cite in their response involve a slip and fall by a visitor at a healthcare provider. That's not this case. What we have in this case is a resident of the healthcare facility, the assisted living facility, and which it makes those cases inapplicable. And I would also point out that in Ross, the Texas Supreme Court set out 7 factors, which is a sort of a non-exclusive multi-factor test for determining when safety-related claims, which some of these are in this case, whether there is a substantive nexus between those claims and the healthcare. And out of the 7, there are 2 of those that don't apply in this case, which are number 4 and number 6, which number 4 is at the time of injury was the claimant providing or assisting in providing healthcare. And we don't have that in this case because the claimant is the resident. And number 6, if an instrumentality was involved, was it the type used in providing healthcare? And we don't have that in this case either. But out of the other 5, the answer to all of those questions in this case is yes. Whereas in the Ross decision, it was no. And so even based on Ross, this is a case where all of the plaintiff's claims are healthcare liability claims in this suit.
So as I understand it, having looked at the motions, you're claiming that not providing heat or leaving a window open during the middle of Winter Storm Uri was providing healthcare to the plaintiff, the decedent?
So I would say this, the test is not whether or not you're providing healthcare for a safety standards-based claim. Rather, as the Texas Supreme Court points out, is whether the standards on which the claim is based are implicated the defendant's duties as a healthcare provider, including its duties to provide for patient safety. All of those are wrapped up in the duty to provide for patient safety. And in plaintiff's complaint, they allege numerous violations, and even in their response attach the violations from HHSC, which talk about the duties of an assisted living facility under Chapter 247 of the Texas Health and Safety Code. And so all of those issues are wrapped up as duties to provide for patient safety, and which is why the enumerated non-exclusive multi-factor test in Ross, those answers are in the affirmative.
Okay.
And so just to sort of to wrap this portion up, so it's clear in this case that because the defendant is a healthcare provider under the statute, the claims and even the safety related claims are healthcare liability claims based on clear statutory text and undisturbed Supreme Court precedent, that this case should be governed by Chapter 74 of the Texas Civil Practice and Remedies Code. And just as a final point, there were during the Chapter 74 report process, the plaintiffs filed a response to the trial court and said that these claims were governed by Chapter 74 and were healthcare liability claims. In addition to that, when the Court of Appeals issued their memorandum opinion in this case with regard to the appeal of the Chapter 74 decision, they referred to plaintiffs' claims as healthcare liability claims. And so there's really, as from the defendant's position, no doubt that these claims are healthcare liability claims. Thank you, Your Honor. I appreciate your time.
Thank you. Ms. Joseph.
Good afternoon, Your Honor. This case is about the death of Cynthia Pierce. Cynthia Pierce froze to death in an assisted living facility during a winter storm because the heat was out, the facility failed to arrange adequate backup power, and her window was left open. The question before the court is whether the Texas Medical Liability Act applies to limit damages in this premises case. The Texas Medical Liability Act does not apply to this case for two distinct reasons. First, Renaissance was not a healthcare provider protected by the TMLA because it was not duly licensed. The definition of healthcare provider in section 74.001A12A includes only entities that are duly licensed to provide healthcare. The word duly is not surplusage. Courts must give every word effect. And the case that I cite in my response for that point is the Texas Health Presbyterian Hospital of Denton case. Based on Black's Law Dictionary, which courts have turned to in interpreting the TMLA, the duly licensed means that the license is held in accordance with legal standards. Renaissance's license was not held in accordance with legal standards. The Health and Human Services Commission investigated Renaissance contemporaneous with Ms. Pierce's death, and they found non-compliance, an immediate and serious threat to residents, and that licensure was not recommended. And this is all reflected in plaintiff's exhibits A through C. The defendant points to, in their briefing, a post-remediation compliance visit that occurred 2 months after Ms. Pierce died in April of 2021, but the documentation from that visit does not establish that Renaissance was duly licensed at the time of Ms. Pierce's death. Because of Renaissance's existing licensing violations, it was not duly licensed at the time that Ms. Pierce died. Therefore, Renaissance does not meet the statutory definition of healthcare provider and cannot and should not receive the benefits of the statute, especially in this case where the licensing violations contributed to the harm. Renaissance contends that duly licensed simply means that a license was issued in accordance with legal standards, but every valid license is issued in accordance with governing standards. Renaissance's construction adds nothing to license, and it renders the word duly within the statute meaningless. Section 74.001 actually uses the word licensed in multiple definitions, but it reserves the modifier duly for one place, and that is the healthcare provider definition. That's the gatekeeping definition that determines whether an entity receives Chapter 74's protections. I have not found a Texas case or even a case outside of this jurisdiction that's interpreting this exact point of what duly licensed means in the statutory language. But giving effect to the use of duly licensed to provide health care requires more than that a license was issued. It requires that the facility hold the license in accordance with the legal standards, and that is be in compliance with licensing requirements. Renaissance's reading collapses duly licensed into simply licensed, and it violates the well-recognized principle that courts afford meaning to all of a statute's language. It erases the legislature's deliberate choice to tighten the language precisely where it confers significant statutory benefits. The burden is on the defendant here to prove that it was duly licensed, and Renaissance cannot carry that burden on this record. So that's point one. Renaissance does not meet the statutory definition of healthcare provider and is not entitled to TMLA protection. Point two, the plaintiff's claim is not a healthcare liability claim because there is no substantive nexus to healthcare. And this is the point where you heard my friend Mr. Cornwell discussing the Ross case and the Ross factors. In that case, the Supreme Court specifically outlined the 7 factors for consideration in determining whether a substantive nexus existed to healthcare, and also explained that that nexus must be a but-for cause, not merely the injury occurred at a facility. So it's more than just the location that's needed here. The duties at issue here, the duty to maintain heat, keep backup power operational, keep a window closed during a winter storm, just don't have a substantive nexus with medical care. And we did cite some visitor slip and fall cases in our response, but you'll see that we also cited some other cases as well that support our position. In Liebman, for example, the patients were, in Liebman, the physician wrote a letter related to a patient needing a service dog. This had nothing to do with a slip and fall. In Lasiga versus Serta, which was sent back for closer examination of the facts, the court actually didn't determine this is an HCLC or not. But in that case, the plaintiffs had claims directly against the physicians for conduct during their medical exams. So our authority is not limited to slip and falls. And defendants' cited cases do not control here either, as outlined in our response. There is something that I feel like I need to bring to the court's attention on this matter. This is a case that was not cited by the defendant, but I think it's appropriate to, again, like I said, bring to your attention. That case is called Collin Creek versus Faber. It's a 2023 Texas Supreme Court case found at 671 Southwest 3D 879. In the Faber case, a resident of an assisted living facility was seated on a walker and being pushed by an employee when the wheel caught in a crack in the sidewalk outside the facility. The resident fell and suffered injuries that led to their death. In that case, the court summarily said that an assisted living facility was a healthcare provider based on its license. The Duly argument that we bring you here today was not before the court in the Faber case. The court also broadly interprets Ross's substantive nexus test to find that the claim in the Faber case was a healthcare liability claim. But our case is different under Ross factors 1, 3, 6, and 7. Factor 1, in Faber, an employee was assisting a patient pursuant to her service plan when the incident occurred. That's not the case here. Factor 3, in Faber, assisting with patient ambulation was a healthcare duty for that specific patient. Again, not the case here. Factor 6, in Faber, the rolling walker was an instrumentality used in providing healthcare. Here, no instrumentality was involved. Factor 7, there was no indication in Faber that the assisted living facility's decisions regarding sidewalk maintenance would have been motivated by specific non-healthcare specific safety standard. Here, we argue that providing heat is a broadly applicable non-healthcare specific safety standard. Renaissance's own contract also confirms that it was not providing healthcare, and this is Plaintiff's Exhibit D. The contract describes Renaissance's services in custodial and hospitality terms and expressly excludes the provision of healthcare. If Renaissance itself said it wasn't providing healthcare, it doesn't make sense that it now claimed Chapter 74 protects it. In addition to the Ross substantive nexus factors, Renaissance's contract, the lack of need for expert testimony also informs the decision here. Courts ask whether the claim requires expert medical testimony. A lay jury does not need an expert to understand that leaving an elderly woman in a freezing room with an open window during a winter storm is negligent and dangerous. Emergency generator maintenance and winter weather preparedness are premises obligations, not medical ones. So point 1, Renaissance does not meet the statutory definition of healthcare. Point 2, plaintiff's claim is not a healthcare liability claim. For these reasons, the court should deny the defendant's motion. But I would address quickly this judicial admission argument as well. Plaintiff is not precluded from her arguments today because no judicial admission occurred to control this issue. The defendant argues that plaintiff admitted that Chapter 74 governs this case based on a single statement in a 2023 brief addressing the expert report requirement. Plaintiff's statement was not a judicial admission. And I do want to make a correction to something that I heard earlier. I heard it said that plaintiff admitted that Chapter 74, quote, governed this case. And the statement at issue is plaintiff saying that this case is, quote, subject to Chapter 74. And I would say to you, Your Honor, that there is a difference between that phrasing. Recognizing that this case is subject to the expert report requirement of the TMLA is not the same as conceding that the damages limitations apply. As I'm sure the court is well aware, procedural compulsion required plaintiffs to serve expert reports, else risk dismissal with prejudice if her claims were found to be healthcare liability claims. In addition, healthcare liability claim status is a question of law. It's not a fact subject to admission, and parties can't admit or stipulate to questions of law as stated in defendant's own, a case cited in defendant's own brief, the Holy Cross case. Plaintiff's live petition expressly disavows the TMLA. That's the operative pleading here. You'll see in plaintiff's briefing as well, significant distinguishing factors amongst the cases that defendant cites to support this position and this case. In closing, Chapter 74 was enacted to address medical malpractice claims, not shield facilities from accountability when their residents freeze to death due to a failed generator and an open window. Chapter 74 does not apply to limit damages in this premises case because Renaissance does not meet the statutory definition of a duly licensed healthcare provider, and plaintiff's claims are not healthcare liability claims. Plaintiff respectfully asks the court to deny defendant's motion.
Thank you, Ms. Joseph. Ms. Watson, do you have anything that?
Yes, Your Honor. First of all, if I start coughing, I apologize. I'm getting over pneumonia, so I'm going to try to get through what I have to say without doing that. So I support Renaissance motion, and at the time of the original filing of this case, initially I represented two defendants, Ms. Ramsey and Rochelle Alvarado, who is a nurse. She was one of the 3 nurses employed at Renaissance at the time of the storm. The initial Chapter 74 reports that were filed by plaintiffs included 2 business executives who wrote reports and an MD pathologist, but there was no LVN or nursing expert report that was produced at the time. And as you've heard, the reports were challenged based upon the defendant's belief that they did not satisfy Chapter 74. The trial court dismissed or did not rule in our favor. We appealed the interlocutory appeal to the Court of Appeals. And during the briefing process, there was voluminous briefing, and the plaintiffs never denied that they were subject to or governed by Chapter 74 during that process. And so the court is invited to look at the court's opinion, the Court of Appeals opinion in the case, because they go into great detail about the fact that this case is a Chapter 74 case. The plaintiffs amended their petition shortly before the opinion came out on February 14th, 2025, which was more than a year after they initially filed their lawsuit. And at that time, they dropped Rochelle Alvarado, the nurse. Obviously, we believed it was because they couldn't come up with an expert to testify against her as a healthcare provider. So this argument about not duly licensed has just recently surfaced. And what has struck me is the fact that they're claiming that because of a subsequent investigation that was started as a result of the storm and the residents' experiences during the storm by HHS, that meant that the license was not, using the word duly, was not, I guess, valid or in effect. And there's no precedent for that argument at all that I can find. And it would mean, if the court accepted the argument, that whenever any sort of healthcare provider becomes involved in an investigation by their licensing authority, that it would be open season for someone to sue them because their license is not duly in effect. And that just is simply not the case. I mean, licensed physicians are subject to their licensing agency, the Texas Medical Board, and their investigations that go on all the time about different things that doctors are involved in. And the same goes for nurses. And the same goes for healthcare institutions, hospitals, assisted living facilities, and skilled nursing facilities. So this is just a very creative argument, I think, that the plaintiffs have come up with in a very kind of desperate attempt to convince the court that this case falls out of Chapter 74 and loses the protections that the statute has provided to healthcare provider and facilities like assisted living facilities. And that's really all I have to say in addition to what Mr. Cornwell has already presented to the court. Thank you so much.
Thank you. Mr. Cornwell, briefly, because I think we've gone past y'all's announcement at this point.
Yes, Your Honor, my apologies. Just very briefly, I just want to walk through a couple of the claims that are actually pled in plaintiff's complaint to show you that these claims are healthcare liability claims. So, for example, they claim the defendants failed to timely and appropriately monitor and record Ms. Pierce's condition, including her deterioration, to properly document and convey changes to responsible physicians for appropriate intervention, to use systemic approach by nursing staff to provide required nursing and emergency care to resident patients, to properly train, orient, supervise staff assigned to care for Ms. Pierce, to appropriately train, orient, supervise staff on emergency preparedness and responses, to properly equip the facility where Ms. Pierce lived with emergency power, to take reasonable measures to prevent residents from developing hypothermia, to provide appropriate essential care to Ms. Pierce. All of these fit squarely within the definition of healthcare, and which does not just limit itself to the words healthcare. I mean, it means an action against a healthcare provider or physician for treatment, lack of treatment, other claimed departures from accepted standards of medical care or healthcare or safety or professional or administrative services. And so I would just, I say that so that the court can have a greater understanding of what the claims are that are being brought in this lawsuit. And we would urge the court to grant defendant's motion. Thank you very much, Your Honor.
Thank you. I want to go back and read the Court of Appeals opinion and look at the pleading. Does anybody have a proposed order? And I'll get you all one, if not today, tomorrow.
Your Honor, I have a proposed order. I can either submit it online or through however the court would like.
Also submitted a proposed order denying the motion in box, Your Honor.
Okay, if so, the plaintiff's motion is in box. If you want to, Mr. Cornwell, you can send it to my submission email address with the note that it's from today's hearing. I'll give you that. It's my court number, which is 419.submission@traviscounty, all spelled out, tx.gov. So be sure and put the cause number, the name of the case, and say that this is a proposed order from today's hearing.
Yes, Your Honor. Thank you.
Okay.
I know we've exceeded and you're wrapping up. May I say one more sentence to you?
Yes, one more sentence.
What the defense argued about our interpretation of duly licensed is actually that our interpretation is illogical, is actually the opposite is true. The defense argument would mean that healthcare facilities don't have to comply with their licensing requirements once they are licensed.
Okay.
So, thank you.
Thank you all very much. I'll get you a ruling real quickly. Thank you.
Thank you, Your Honor.
Your Honor,
Thank you. You may be excused. Y'all can log off if you want to.
thank you.